Hello, everyone. This is Stephen Richardson. Um, going to be talking to you today about a contracts law exam question from the Cal Bar, February 2012. We'll look at the fact pattern, call the question, and then we'll answer. I'll outline those using my guides from lawschool-essentials.com, and then um, very briefly do the IRAC analysis so um, you have an idea how to do this. Okay, so these were the instructions on the February 2012 Cal Bar exam. Um, the standard stuff, you can get it online. And I'm going to be using my mnemonic memory guides from lawschool-essentials.com. During a test like this, you really have to regurgitate this information. You don't have time to be wondering if it's this or that. You really have to memorize it. And I use mnemonics to help you remember. So head on over there to take a look at the products. Okay, so first thing you do is read the call to question. On what theory or theories may Examco bring an action for recovery of damages against Tesco? So that's a contract law right there. And then Amy, Ben, and Carl as individuals. So now we're probably corporate law, but you need to read and take a look closer. Tesco Incorporated conducts market surveys solely owned by Amy, Ben, and Carl. Each paid $50 for one-third of Tesco's no par shares. Amy and Ben, respectively, are Tesco's president and secretary, and is only two directors. Okay, so this is a corporate question. Part two is Amy and Ben are scrupulous about holding directors' meetings to conduct corporate business. Okay, so that means you can't pierce the veil because of the identity that they're scrupulous about their meetings. Amy and Ben are scrupulous about holding director meetings to conduct corporate business and to make monthly distributions to the shareholders, almost all cash on hand. So right there, cash on hand lets you know that capitalization might be undercapitalized. As a result of the latter practice, Tesco has little cash on hand and frequently finds itself in a position of negotiating extensions for payment of its debt. Okay, so it can't do its normal business operations. While Ben was on vacation, Examco called Amy asking to enter into a one-year contract with Tesco. Amy said that if Examco would agree to a 10-year contract, Tesco would grant its standard 50% discount. Okay, so we're terms here, offer, counter offer. Examco agreed and Amy signed the contract. Okay, so there's acceptance, and the consideration is probably money for services. In the following manner. So she signed it in the following: Tesco by Amy, president. It's kind of strange. Usually you sign your signature. When Ben returned, he said that he had thought for some time that Tesco's standard 50% discount was unwise and convinced Amy to revoke the contract with Zamco. Revocations or cancellations are sometimes necessary, but they are always expensive, let me tell you. Okay, so you've been looking at the side here about things that you're thinking about, right? So we'll move on. Okay, so from my outlines, this is a contract question. First thing you're looking at is formation and defenses to formation, and then the actual performance. Was there a breach? So that's what you're going to be looking at. You should take about 10 minutes to organize these thoughts into the formation, the defenses, and performances. And we can see that the offer, the counter offer, the acceptance. Now the signature is in question. You might want to take note that in the UCC, a signature is acceptable as any mark or that evinces assent, and it could be a stamp or anything. That's not persuasive, but it's you can note that. Um, and then let me see. And then moving on to the breach. Um, this is an anticipatory breach, and is it material? Yes, it's material because Tesco is not wanting to perform anything. It's kind of assumed that they haven't gone into business yet. They haven't gone into uh, haven't done any performance yet. From the fact pattern, it doesn't say that they performed. Okay, so let's move on to how the IRAC would look. So first thing, always on a contracts question, which law governs? Is it common law or UCC? UCC is goods. We're not dealing with goods. So we're dealing with the common law because there's different definitions, different rules of law. Okay, is there a contract between Examco and Tesco? Let's see. We're going to look at that. A contract is formed. There's mutual assent, offer, and acceptance. Okay, I'm not going to read it verbatim here, but the offer, acceptance, and consideration. Remember, there's a counter offer. So you don't have a lot of time to be thinking about this. You just have to regurgitate it from memory. And my mnemonic aids over at the website at lawschool-essentials.com helps you to memorize this, right? And this just isn't for bar exam questions. This is for your law school exams when you're going to law school, right? And you're in your contracts class. So in the analysis, Tesco contacts Examco and makes an offer. Tesco president counter offers. Sorry, Examco contacts Tesco. Um, so that counter offer is a rejection of the original offer and is now a new offer. Amy is the president. Most presidents can bind their companies into contracts. Examco agreed to the counteroffer. Consideration appears to be money. So there appears to be a valid contract, but it needs to survive the defenses to enforcement. So now you come over here. Are there defenses to enforcement? In order for the contract to be enforceable, it must survive the statute of frauds. If fraud or misrepresentation occurred during the negotiating process, a contract can be held voidable, right? So in your analysis, we're talking about the signature. It was kind of strange. Tesco by Amy president. So you can argue that since she's the president, that writing it in this manner evinces that she's making a mutual assent to the deal. And then I told you, you might want to mention the UCC, that the signature is an individual mark, any mark or symbol um, could show that it's a signature. Okay, and um, Amy used her name, identified her position with Tesco. There could be a mistake about the amount of the discount. That's not going to work because mistakes have to be factual mistakes. They can't just be do over 50%. We want to renegotiate it to 20. That doesn't happen. The amount of the discount is not factual. The subject of the contract would be factual. So now you make your conclusion, wrap it up, the whole conclusion that it's either valid or not valid, or appears to be. Don't be conclusory. Okay, so the breach. Now you got to talk about the breach. Did Tesco breach the contract with the Examco? So you define breach. Breaches of a contract's failure without any excuse to perform any promise that forms all or part of the contract. An anticipatory repudiation occurs when the party clearly indicates, whether by words or actions, that they will not perform the contract, right? And a material breach occurs when there's a serious violation so that the contract is jeopardized. And now you go into your analysis. Amy revoked, so that's a clear anticipation. And it seems like it's before any performance. So this appears to be a material breach when Tesco refuses to perform any part of their promise. So make your conclusion that don't be conclusory. It appears that, um, assuming that, and then make your conclusion. So now, remedy. If you have time, if time permits, you talk about a remedy. And so some of your remedy would be expectancy damage and consequential damages. But the problem with this is that you can't foresee 10 years out or 8 or 6 or 5 years out what how much business is going to be, what the damages would be. So that's a problem. And there's no liquidated damages. Um, so or agreed upon. It doesn't say there was agreed upon. So it looks like the remedy here is specific performance. And then make your conclusion. This will give you a few extra points on the exam. Okay, now against Examco versus shareholders, Examco may pierce the corporate veil only under certain 3 circumstances: instrumentality, undercapitalization, and dividend liability. The first 2, or the first and third, do not apply, but you might want to mention it so that you know what you're talking about, and then focus on undercapitalization. And there's 2 tests: New York test, California test. New York is more stringent about piercing the veil. California test is the fairness test. So this is how the answer would look. Was Examco undercapitalized to carry on business operations? A company with sufficient capital to achieve desired results is under capital, insufficient capital for normal operations. That's the fairness test. Examco may pierce the corporate veil only under certain circumstances. Dismiss the instrumentality and the dividend liability right away. And then the directors make monthly distributions to shareholders, almost all cash on hand. That's a fact. Consequently, the company doesn't have enough for normal business operations. And then you can say that the court can require the shareholders to return distributions so that normal business operations can be executed, and then make a conclusion. So all of these have taken 50 minutes to do. So you've got about 10 minutes to tighten it up, work on the remedies, and just tweak it a little bit. So again, you've got to know these. You've got to have them memorized and pull them out word for word. And my products over at lawschool-essentials.com does that. It helps you do that. Read it, write it, repeat it. Thanks a lot, and I'll see you on the next one.